Hello, house guests, and welcome back to another live of court filings. This one was actually filed yesterday in the Jonesworks matter, which I'm going to tell you is probably going to be juicier than the Blake Lively matter. Sorry, guys, I have very lazy speech today, so I apologize. So this one was filed by Jonesworks. It's an answer. It looks like it's an answer to 639 answer to a minute complaint, third party complaint with jury demand. I want to be on that jury. Please let me be on this jury. I'd rather be on this jury than Blake Lively's jury. I'm going to start off with third party plaintiff Jonesworks LLC. Jonesworks answers the third party complaint filed by defendant and third party plaintiff Jennifer Abel as follows. Jonesworks lacks knowledge of information sufficient to form a belief as to the truth or falsity of the allegations in paragraph 1. Jonesworks admits that it is a Delaware limited liability company with its principal place of business in New York, New York. Side note, this is where I think they went wrong. If Blake Lively pulled in Jonesworks and said, my principal place of business is New York, maybe she would have had a better shot at jurisdiction. I'm not a lawyer, but I always wondered this. Moving on. Jonesworks further admits that Stephanie Jones is not a resident of California and lacks knowledge or information sufficient to form a belief as to the truth or falsity of the remainder of the allegations in paragraph 2, including because the term members is vague and ambiguous. Now, I don't have the other complaint in front of me to see paragraph 2, but that's interesting. The allegations in paragraph 3 are legal conclusions, and therefore no response is required. To the extent a response is required, Jonesworks denies these allegations. Oh man, we need to have this complaint pulled up. I am so sorry. That'll be another video. Again, the allegations in paragraph 4 are legal conclusions, and therefore no response is required. To the extent a response is required, Jonesworks denies these allegations. Oh yeah, this is the I didn't think they filed another amended, but anyways, the allegations in paragraph 5 are legal conclusions and therefore no response is required. To the extent a response is required, Jonesworks denies these allegations. 6. The allegations in paragraph 6 are legal conclusions and therefore no response is required. To the extent a response is required, Jonesworks admits that it conducts business in New York and denies the remaining allegations. The allegations in paragraph 7 are legal conclusions and therefore no response is required. To the extent a response is required, Jonesworks admits that it conducts business in New York and denies the remaining allegations. The allegations in paragraph 8 are legal conclusions and therefore no response is required. To the extent a response is required, Jonesworks admits that a substantial part of the events or omissions giving rise to these claims occurred in this district. I really need to look that up. Okay. General allegations. Jonesworks admits that it is a New York-based public relations firm founded by Stephanie Jones, who serves as its CEO. Jonesworks denies that the allegations of paragraph 10 provide a complete and or accurate description of the matters purportedly described therein. Jonesworks admits that Stephanie Jones is married to Jason Hodes, who is a partner at William Morris Endeavor. Jonesworks denies the remaining allegations, including the characterizations contained therein. Jonesworks admits that when it hired Jennifer Abel, she worked for RNCPMK. Jonesworks denies that Stephanie Jones poached Jennifer Abel. Jonesworks lacks knowledge or information sufficient to form a belief as to the truth or falsity of the remaining allegations. Jonesworks admits that Abel was connected to Jonesworks through a recruiter. Jonesworks lacks knowledge or information sufficient to form a belief as to the truth or falsity of the remaining allegations. Jonesworks denies that Stephanie Jones has become embroiled in a dispute with another public relations firm for stealing its clients using deceptive and unscrupulous means. Jonesworks lacks knowledge or information sufficient to form a belief as to the truth or falsity of the remaining allegations. 15. Jonesworks lacks knowledge or information sufficient to form a belief as to truth or falsity of the allegations. Jonesworks admits that Abel was hired on July 9, 2020 with the title of Vice President. Jonesworks denies the remaining allegations. Jonesworks admits that as a condition of her employment, Abel execute a non-disclosure and intellectual property rights and non-solicitation agreement, the Abel NDA, which document speaks for itself. Jonesworks admits pursuant to the Abel NDA, Abel was an at-will employee whose employment was exclusive to Jonesworks during the period of her employment, and that the Abel NDA speaks for itself. Paragraph 19 purports to summarize a document that contains of which for itself. Jonesworks admits that on November 22, 2021, Abel executed a modified employment agreement, which document speaks for itself. Jonesworks denies the remaining allegations. Paragraph 21 purports to summarize a document, the contents for which speak for itself. Paragraph 22 says the same thing. The allegation in 23 is a legal conclusion, therefore no response is required. To the extent a response is required, Jonesworks denies this allegation. Jonesworks denies that Abel performed no work for Jonesworks in the state of New York. Ooh, here it gets juicy. Jonesworks denies that Abel performed no work for Jonesworks in the state of New York, and that she performed overwhelmingly majority of her work in the state of California. Jonesworks admits that Abel has worked out of Jonesworks' Los Angeles office. The remaining allegations are legal conclusions to which no response is required, or Jonesworks lacks knowledge or information sufficient to a belief as to the truth or falsity of these allegations. Jonesworks denies the allegations in paragraph 25. Jonesworks admits that while Abel was employed at Jonesworks, she worked on the Justin Baldoni and Wayfarer accounts. Jonesworks lacks knowledge, information sufficient to form a belief to the truth or falsity of these remaining allegations. Jonesworks denies the allegations in paragraph 27. Jonesworks admits that only July 10, 2024, Abel purported to resign during a Zoom call and subsequently sent an email regarding her purported resignation July 26, 2024, which did not disclose her intention to use Jonesworks resources or solicit Jonesworks employees and clients in violation of her agreements to commence a competing business. Jonesworks admits that Abel offered to stay on for a 6-week transition period and also communicated her intention to start her own business in the future, and denies the remaining allegations. Answering paragraph 29, Jonesworks admits that on August 21, 2024, it terminated Abel's employment. Jonesworks admits that December 31, 2024, Blake Lively filed a complaint, which document speaks for itself. Jonesworks admits that on July 30, 2025, Lively filed a second amended complaint. The document speaks for itself. Jones admits that Wayfair and Baldoni were clients of Jonesworks. Jonesworks denies the remaining allegations in paragraph 32. Jonesworks admits that Wayfair and Baldoni were clients of Jonesworks. Again, denies remaining allegations in 33. Same thing for 34. Denies allegations in 35. Admits that it generally gave Abel directions to carry out the duties of a competent public relations professional on behalf of its clients. Jonesworks denies that the conduct alleged in Abel's complaint or alleged by Lively against Abel fell within these directions. And then it just says Jonesworks denies the allegations in paragraph 37, 38, 39, and 40. 41 requires no response. The extent of response is required. Jonesworks incorporates the above answers as set forth within. Paragraph 42 requires no response. To the extent a response is required, Jonesworks states that the text of California Labor Code section 2802A speaks for itself. For paragraph 43 requires no response. To the extent a response is required, Jonesworks states that the text of California Labor Code section 2802C speaks for itself. And then 45 denies allegations. 46 are legal conclusions. So is 47, 48, 49, 50, and 51. Now we're on to our second cause of action. 52 requires no response. Paragraph 52, that is. To the extent a response is required, Jonesworks incorporates the above answers if set forth herein. And that's the same. Again, denies allegations in 53 and 54. It's just denying it for 55 all the way through 61. And then we have a third cause of action. Again, affirmative. So I just skipped down to everything because it was more of the same thing, just denying. By alleging the following affirmative and other defenses, third-party defendant Jonesworks is not in any way agreeing or conceding that it has the burden of proof or burden of persuasion on any of these issues. As a separate and distinct defenses to Abel's amended third-party complaint and each purported cause of action contained therein, Jonesworks alleges as follows. First defense, the amended third-party complaint, each claim alleged within fails to state sufficient or facts sufficient to constitute any claim for relief against the third party. The admitted third-party complaint, each claim alleged therein is barred as third party lacks standing to sue. Ooh, maybe they have a mediation claim. The amended third-party complaint, each complaint alleged therein is barred as third-party plaintiff has waived her claims. Fourth defense, the amended third-party complaint and each complaint therein is barred as third party is stopped from asserting her claims. She's got a lot of defenses. The third-party complaint, each claim is barred as third party acted and continues to act with unclean hands. Juicy. Sixth defense, the amended third-party complaint and each claim alleged therein is barred as third-party plaintiff has not been damaged in any way or at all as a result of any alleged acts or omissions of the third-party defendant. Seventh defense, the amended third-party complaint, each claim alleged therein is barred as third-party plaintiff has failed to undertake reasonable measures to mitigate the damages she claims to have incurred. Any recovery by third-party plaintiff must be diminished to the extent that any alleged damages could have been avoided if such measures had been undertaken. Eighth defense, third-party defendant is informed and believes and on that basis alleges that third-party plaintiff would be unjustly enriched if recovery were to be had on this amended third-party complaint. Y'all, there's a 9th, 10th, 11th defense, 12th defense. Ooh. Stephanie Jones has like 15 defenses here and a demand for a jury trial. That's crazy. All right, let's go. I didn't think this thing was going to be that long. 9th, where are we at? Okay, 9th. Third-party plaintiff has not been damaged in any amount alleged or in any amount whatsoever and is not entitled to any general compensatory, statutory, punitive, or other damages, including interest or any other relief as a result of any of the allegations set forth in this amended third-party complaint. The act and omissions excused alleged failure, the damages and injuries, if any suffered, were directly and approximately caused solely by the acts or omissions of individuals or entities that third party. The acts or and omissions of such individuals or entities are superseding and intervening cause of loss. As a consequence thereof, third party plaintiff is barred from recovering against this third party. 12th, third-party defendant alleges that in the event it is found in some manner legally liable to third-party plaintiff as a result of the events or occurrence described in the amended third-party complaint, which the third-party defendant specifically denies, that liability will be solely based upon a, oh my God, I'm going to butcher the name, derivative, vicarious, or imputed form of liability not resulting from its own conduct, but instead based upon an obligation imposed upon by law or by the conduct of others. And as such, legal liability of the third party would be proximately caused by the acts or omissions or of others, and therefore third party defendant is entitled to recover contribution from them. Third party alleges damages are too speculative to make recovery in this case. The amended third party in each and every cause of action alleged therein is barred in whole or in part because the third party plaintiff bears at a minimum at least partial, if not full, responsibility for the alleged wrongful conduct underlying her claims. Third party claims based upon California statutes are barred because third party does not allege that the third party defendant took any wrongful actions within the state of California. Within the state of California, and California law does not apply to third party plaintiffs' claims. The amended third party complaint in each claim alleged therein is barred as third party plaintiff breached her contract with the third party defendant. Oh my God. So we have breach of contract. Ooh, we have it's your fault. Third amended complaint. Each claim alleged herein is barred by third party breach of fiduciary duties to the third party defendant. So she was acting in bad faith. It sounds like I'm not a lawyer. Reservation of additional defenses. Third party defendant presently has insufficient knowledge or information on which to form a belief as to whether it may have additional or yet unstated affirmative or other defenses available. Third party defendant reserves the right to assert additional defenses in the event that discovery indicates that it would be appropriate. Prayer for relief. Wherefore, third party defendant Jonesworks prays for relief as follows: the amended third party complaint be dismissed with prejudice, and the third party plaintiff take nothing herein. The judgment be entered in favor of the third party defendant and against third party plaintiff for cost of suit and attorney's fees occurred in this action. Everybody's asking for sanctions. I mean, I swear everybody is. For such and other further relief as the court may deem just and proper. Third party defendant demands a jury trial on all causes of action so trialable. Wow. All right, guys. So there you have it. That was Stephanie Jones' answer. It's pretty interesting. Maybe we'll do a deep dive in it a little bit later. But for right now, I'm going to go back to bed because I am tired. Don't forget to subscribe, share, and comment. We do have other podcasts on our channel. So don't be afraid to take a look. All right, house guests, we'll see you next time.